I think we shall now get started. Thank you all for joining us. Today, Professor Kimberly Kessler Ferzan, who is the Earl Hepburn Professor of Law and Professor of Philosophy at University of Pennsylvania, will be presenting for us on her paper, Detention and Distrust. The floor is yours. Thank you so much for joining us.
Thank you all for coming and for having me. I look forward to your questions. When you ask a question, if you can tell me who you are, and if I don't already know, that would be terrific. That way, what happens won't be what happened when David Enoch presented a paper years ago criticizing Kimberly Kessler. And when he finally sat down, I said, "Why are you picking on me?" And he said, "Kimberly Kessler Ferzan is Kimberly Kessler." So it would be nice to know who's out there. Well, I'm the speaker, so it's my way. Okay. But anyway, so this paper is called Detention and Distrust. It's very much a work in progress and definitely hasn't been like submitted anywhere. Definitely appreciate any feedback you guys have for it. So imagine that every time someone went to buy some milk, their payment would initiate an algorithm. Big data, the great algorithm, as I'll call it, would determine if they were dangerous, and if so, they would be immediately be detained, even if they had a spotless record. Now consider a defendant who has been charged with armed robbery and has a criminal history, say assault and arson, and the state is deciding whether it may detain the defendant pretrial. Assuming the great algorithm suggests that the milk buyer and the armed robber are equally likely to commit a violent crime in the near future, what, if anything, normatively distinguishes these cases? Sandy Mason endorses the parity principle, maintaining there is no difference. We should only detain people pre-trial to the same extent that we are willing to detain the milk buyer. Anthony Duff agrees. He maintains that the defendant is entitled to trust, an entitlement that is returned to him after he has been criminally punished. Current practice, however, denies the parity principle. We aren't keen to detain responsible agents based on algorithmic predictions, but we will detain the charged defendant, and indeed criminal history and pending charges are the two most important factors in detention and bail decisions. I think we can and should deny the parity principle. Both criminal history and pending charges implicate the possibility of forfeiture, something that is not at stake for our milk buyer. Forfeiture views are proliferating. Alec Wallen argues that criminal defendants can forfeit a status of being treated as presumptively law-abiding, such that they can be subject to long-term preventive detention after their carceral sentences have ended. Zach Hoskins contends that offenders can be liable to a limited set of collateral consequences after a criminal conviction. Jeff McMahon maintains that one's responsibility for appearing to pose a threat can render one liable to another person's reasonable mistake. And Renee Jorgensen's signaling view of self-defense could count committing an offense as a signal of aggression, the kind of signal that one had the ability to avoid sending. So we have a question. If there is a presumption of innocence, trust, or presumed status of law-abidingness, one that presumably protects us from the great algorithm when we are simply buying milk, under what conditions can we forfeit it? And if we can, what precisely would this forfeiture consist in? Though I don't endorse anything like our current practices for pretrial detention, which are wildly over-inclusive and often dehumanizing, I want to suggest that if we pry apart our prevention goals from our punitive ones, we can make space for denying the parity principle. The presumption of law-abidingness can be lost or weakened, rendering it easier to detain repeat offenders. Moreover, the showing for the loss of the presumption need not be beyond a reasonable doubt. Seeing the broader applicability of forfeiture principles generates a fuller understanding of the stakes and distinctions. So let's begin with a sketch of the current legal framework, at least in the US. Throughout the United States, almost 500,000 defendants are detained pretrial on any given day. How'd they get there? Most of them were deemed dangerous. Even though we once were more concerned with failure to appear or obstruction of justice, dangerousness has eclipsed both of those concerns in justifying detention and bail. Dangerousness detention can be overt or covert. Overtly, there's just outright detention. There's a formal system based on a number of factors. Defendants are afforded robust procedural protections, like attorneys, etc., and the evidentiary burden is clear and convincing evidence. However, because outright detention on dangerousness grounds requires a rigorous inquiry, courts often use their discretion to do covertly what they can't do overtly. They simply set bail too high for defendants to meet it, thus effectively detaining the dangerous, even though they're not really permitted to do that. State bail decisions are often made in a couple of minutes and even without representation by a defense counsel. The two most important factors empiricists have found are criminal history and the seriousness of the crime charged. So taking a step back, how is it that our moral rights intersect with the state's interest in detaining us on dangerousness grounds? It's generally impermissible to lock someone in a cell. They have a right against such treatment. The question then is, what would render such conduct permissible? One path to permissibility is that the actor has done something such that no right stands in the way. Consider self-defense. If Alice threatens to kill Betty, then Alice is not wronged by the use of force against her. We may say that she's liable to defensive force or that her culpable aggression forfeits her right. Notably, even if there is forfeiture, the use of force must be, all things considered, permissible. If Betty can just yell at Alice, then she may not shoot her. In contrast to forfeiture, sometimes we may override the rights of an innocent person. For instance, the trolley problem. Most people think it's permissible to divert a runaway trolley from 5 trapped workers to only 1. The one worker has done nothing to forfeit his rights, but the strength of the claims of the others justifies infringing them in this case. There's also an epistemic overlay here. What if we're unsure if the person is liable? Otto Haack presents a scenario where a soldier standing next to 4 of his fellow combatants does not know whether a person is an insurgent with a grenade or a civilian holding a soda can. Haack argues that the soldier must believe the target is liable. Whether one adopts a belief-based standard or a credence-based standard, such as more likely than not, what matters is that the determination doesn't change based on how many people may be harmed. This is an anti-aggregation principle that protects the separateness of persons. You shouldn't require only 1% confidence in liability if there are 100 lives at stake. In instances in which the epistemic threshold is not satisfied, a defender may only act when it would be permissible to do so when one knows the target is innocent. So turning to pretrial detention, dangerousness encompasses 3 potential justifications. First, detention may be justified due to the underlying criminal case, essentially borrowing against future punishment. However, this approach raises concerns. It allows the state to justify punishment without meeting the burden of proof, it blurs the expressive function of the criminal law, and it unfairly affects the innocent. Second, detention might be just predicated on a specific threat the defendant currently poses. In just the same way that self and other defense authorizes the use of force against someone to stop a threat, so too we might think detaining someone pre-trial is permissible when he'll otherwise kill a witness or harm someone. The crucial inquiry here is when the defendant has engaged in the sort of action with the required mental state so as to have forfeited rights. If someone has a current criminal intention, I've argued that's sufficient for defensive and more generally preventive interference. In contrast to these 2 sorts of justifications, punishment and already being liable to preventive interference, consider a third, the amorphous future threat conception of dangerousness. If our commitments to the presumption of innocence prevent us from detaining someone prior to trial by drawing on his alleged guilt for the crime charged, and if we lack sufficient evidence to believe that at this moment he has the intention to commit another crime, or has met whatever threshold is required by one's preferred theory of liability, then our intuitive urge to detain him on dangerousness grounds is based on the anticipation that he might become a threat in the future. At first, these amorphous cases look like trolley problems. There's one potential detainee, there's a bunch of people that the detainee might harm. It looks as if we're harming one person to rescue many. However, despite their superficial similarity, detention cases are not trolley problems. The question is not how much harm one may impose on an innocent bystander to prevent injury to 5 others. Instead, the question is how much harm one may impose to eliminate a threat. It is as if you are turning the trolley to the one to prevent what he will otherwise do. To be clear, this is not a forfeiture case, but rather a case in which we predict a future act that would constitute a forfeiture. Accordingly, the question is whether, with respect to responsible agents, the state accords them the trust and respect to which they are entitled if the state aims to eliminate the threat the defendant poses based merely on a prediction of future wrongdoing. Now, one approach here would maybe simply be to say that we need more justification to eliminatively harm someone than to treat them as a side effect. This would then fall within general deontological principles like doings are harder to justify than allowings and intendings than foreseeings. But the way that the presumption of law-abidingness is intended to function is as a deontological constraint, like the means principle that does not allow one to be pushed in front of a trolley even to benefit 5 others. The idea is one ought not to even be thinking about eliminatively harming someone protected by the presumption. But why are we protected against prediction? Much of the literature frames the problem with predicted threat detention as the problem that prediction is autonomy denying. Prediction, it is thought, is based on not treating the person like an autonomous agent. Some theorists think this objection is not quite right. Acting based on a prediction does not deny the actor has the capacity to choose rightly. Rather, acting on the prediction does not respect that the actor will so choose. As Duff articulates the worry, another way to put the point is to note that in detaining a person on the grounds that they might commit crimes if left free, we are saying to them in a drastically coercive way, we do not trust you. We deny them that trust, that presumption of innocence to which citizens are entitled, to which the detainee can reply, I have done nothing to warrant such a loss of trust. So are we really entitled to anything like a presumption of future innocence? So consider the following. Here's a hypo. Fortuna. Alice goes to see Fortuna, an infallible fortune teller. Fortuna tells Alice that Alice will intentionally kill Carla a year from now unless Alice loses her own leg this month. Bob overhears this fortune. Here's the question. If it is certain that Alice will otherwise kill someone, does she have the duty now to stop her later self, even if it means cutting off her own leg? I suspect you're going to balk on epistemic grounds. You just can't believe this is the only way out. So supplement Fortuna with whatever time-traveling abilities you need on Alice's part, so she can go back and forth in time and she constantly winds up killing Carla until Alice comes to have the evidence she needs to conclude that the only way to prevent Carla's death is to cut off her own leg. At this point, it seems that Alice has a duty to cut off her own leg. And if Bob, also with perfect certainty, of course, were to know Alice would fail to do her duty, then Bob would be permitted to enforce it. Notably, the moral force of Bob's enforcement comes not from a lesser evils balance, but rather from the fact that were Alice to know all the facts, Alice would have a duty to inflict the injury rather than become a killer. If that's true, then our respect for our autonomy is simply the product of our limited epistemic abilities. And to quote Stephen Morse, that autonomy, quote, hangs by a technological thread. Perfect knowledge would always tell us whether we would perform some harm, and then we would have duties to act in ways that prevent those harms. The state would simply enforce the duties we already possess. But we do have limited epistemic abilities. So for all we know, maybe Alice has a duty because she'll otherwise kill Carla, and maybe she doesn't. Alice doesn't even know. The critical inquiry at this juncture is, from our stance as epistemically limited agents, is there any real distinction between instances in which A is trying to discern whether B has already done whatever renders B liable, forming an intention, for example, and those cases in which A predicts B will become liable? So let's first think about the kind of evidence we can use to make these determinations. One reason to care about evidence quality is that we think evidence quality correlates with accuracy. The other reason to care about the quality of evidence is normative. We might think it's unfair to use factors over which the individuals have no control or are significantly influenced by prior unjust distributions. My goal here is not to set forth a theory for this, others have done some of this work, but to note that this concern with the type of evidence will exist for both the already liable and the predicted liable determinations. There's no reason to treat those cases differently. What about the epistemic standard? Consider a burden that individuals need to believe it's more likely than not that a person is an attacker before they may kill in self-defense. In instances of prediction, the predicted attacker might argue that we should not jump to conclusions about them. They should be trusted. But then the person we are evaluating as a current attacker might reply, there's no difference for them. Determining that someone is already liable also involves the decision not to trust them. The determination that they are not trustworthy allows the inference that they have formed the intention. Still, given that we are limited epistemic agents, So long as we are libertarians or compatibilists, we should see a difference between B's claim, I don't intend to kill you, and thus am not currently liable, and I will not form the intention to kill you in the future. It is different in kind for the agents themselves, and that ought to have implications for how we treat the agent. As agents, we do not take theoretical perspectives on our own actions. As Berislav Marusic argues, we don't treat our engagement with the world as a matter of predicting what we will do based on the evidence. His specific concern is how we can rationally promise or resolve to phi when substantial evidence indicates we won't phi. Our lives are full of these cases, from making meaningful wedding vows in the face of evidence of the likelihood of divorce, to resolving to quit smoking in the face of evidence that predicts one will give in to temptation and fail. The puzzle is that sincerity and evidence conflict. How can one sincerely promise to love someone forever in the face of evidence that marriages fail? It seems one must be either insincere or irrational. Ultimately, he rejects that we take a theoretical perspective on ourselves because doing so is denying our own agency. Even our most mundane actions take seriously that we are the authors of our own actions. I eat a banana for breakfast every morning. So today, I might go into the kitchen, not the kitchen, I'm in a hotel, and I don't reason. I have eaten a banana for breakfast every day for the last 100 days. Therefore, I predict I will eat a banana today, right? Rather, I decide to eat a banana, right? Because they're available, they're yummy, they're healthy. I don't want to spend deliberate time deliberating about what to eat because I want to go write philosophy papers, or I'm going to use this as an example today, so I gosh darn better well eat a banana, which I did. Okay, but I in no way view my future action as a matter of prediction, right? In fact, I might form the intention to make eggs, right? The fact that I always eat a banana would be neither here nor there. So it is in this sense that ignoring the presumption of innocence is autonomy denying, not because others deny an actor's autonomy when they predict he will do wrong, more on that in a moment, but because to accept this perspective would require the agent to take a predictive view of his own actions. We can rationally believe against the evidence about what we will do because, as Marusic argues, what we will do is up to us. This only takes us so far. After all, third parties aren't the agents. So what is wrong with their predicting? Marusic draws a stark contrast between those who ought to be partial to the agent, spouses and friends, and thus ought to trust the agent, and unrelated third parties, including a bookie who's apparently placing bets on people's marriages. These people are entitled to take a predictive stance. Of course, if we're all just bookies, then there's no objection here. We should deny the presumption of innocence or law-abidingness tracks anything meaningful. I think there's reason to doubt that. We are asking what we owe each other as part of a moral or political community. Indeed, Marusic himself claims that it is taking a Straussonian participant stance that leads to this obligation of trust. Quote, we should regard others as persons rather than as objects. We should trust or distrust them rather than seek to predict whether what they promise us or tell us is true. Yet this is not a stance limited to the near and dear. It is also in keeping with how epistemology has otherwise been pushing back against purely predictive models of persons, from non-reductionism's view of testimony to doxastic wronging. As Rima Basu argues, people are not objects to be studied, predicted, and managed. Moral communities, then, shouldn't regard their fellow members the way a bookie regards an object he bets on. Nevertheless, though we may owe our near and dear trust, that seems to be a tall order for what we owe our fellow citizens. As members of a moral community, we don't owe the stranger on the street the kind of trust we owe our loved ones. Whatever claim we have on each other as people is different in kind from full-fledged trust. We don't seem to really trust each other, nor is it clear we can will ourselves to trust others. Now, Duff focuses on distrust. Pre-trial detention does manifest distrust. That seems undeniable. Putting somebody in a cage to prevent them from hurting you definitely says you don't trust them. Perhaps we do breach some normative obligation we owe her as our fellow citizen. But distrust as an effective attitude can't be the right explanation for the sort of account that blocks the lesser evils calculation. To be sure, distrust may strike us as hurtful, particularly if distrust can be reduced to a mere prediction of future wrongdoing. But one may distrust someone without ever communicating it. We distrust people when we lock our car doors, yet that's not what's at stake in these cases. So though tight-knit communities may owe each other deeper levels of effective trust, citizens who accept that they will be bound together by a system of rules and joined by common projects can at least demand of each other that they not be treated like a wild dog or a deadly disease. That requires them to give each other not an effective attitude that we cannot fully control, but instead a status that protects us against our natural inclinations to engage in self-protective behavior. We can accord each other a status of being presumptively law-abiding. This status enforces that we at the very least cannot act with distrust toward each other. So let's take stock. My goal for this section has been to render the idea of this status plausible. Without it, I certainly couldn't get to how we forfeit it, right? It would be kind of beside the point. I began with the idea that the presumption of innocence is just a feature of epistemic uncertainty. With perfect knowledge, we'd have duties to stop ourselves from causing harm that we know about. Granting that may be true, the question is how we, as epistemically limited agents, ought to treat each other. And it's noteworthy that some things we find valuable, like trust, are only possible because of uncertainty. If you knew someone would do what you relied on them to do, you couldn't trust them. I then asked whether all questions of epistemic uncertainty are the same. Is there a difference between the already liable and the predicted liable? The crucial distinction, I argued, was that the actor in the predicted liable case cannot view themselves as an object to be predicted. Accepting the truth of predictions when one promises or resolves to do otherwise is a denial of one's agency. I also then argued that participants in a moral community also owe the agent an agential, not predictive stance, and that what we owe each other couldn't be dictated by a requirement of trust, but could be enforced by providing individuals with a status that protects against prediction. So might those who have been convicted of a criminal offense somehow forfeit this protection against the lesser evils balance? The culpable aggressor forfeits rights against proportionate defensive force. Perhaps we can lose our presumptive status that prevents a calculation that we must be detained for the greater good. So let's start with the criminal record. We might think that someone with a criminal record has forfeited his status as presumptively law-abiding. Let me suggest that the commission of particularly serious acts of violence can in fact put someone on moral probation. Such a probation is, from a moral point of view, just one data point on a spectrum of responses to moral wrongdoing. This probation is not punishment, but it is cabined by proportionality concerns in addition to duties that we may owe each other after punishment. So what we owe each other as an initial starting point is to respect each other even in the face of predictive evidence to the contrary. But there is no reason to think that initial stance is not conditional on actually being law-abiding. When a person acts in a way that is counter to that presumption, she forfeits it. The loss of the presumption is not an act that takes her below a baseline to which she is otherwise entitled. If someone drinks and drives and loses her driver's license, the loss of that license is the loss of a privilege that was contingent upon obeying the rules. So too, we might think of deportation as the loss of a privilege to reside in a particular country. Our entitlement to be treated as agents in the face of contrary evidence is predicated on our choosing rightly. We lose the force of that claim when we violate the law. This isn't punishment. It's not about deterrence. It's not about what the person deserves. Rather, it's simply a recognition that wrongdoing may have many different implications. So instead of losing the presumption as a consequence of punishment, I think the relevant question is whether punishment restores the presumption. That's actually Duff's view. He claims the commission of an offense threatens that trust, but by undertaking or undergoing punishment, paying one's penal debt, that trust is taken to be restored. But restoring the presumption requires a very particular view of punishment, such as Duff's that one's engaging in secular penance that restores one's status as part of the moral community. But it isn't clear that much of our understanding of punishment requires this. Interpersonally, if I punish my son, say, for speeding in my car and getting a ticket, I might ground him for 2 weeks as his punishment. But the fact that I entrusted him with my vehicle and that he violated that trust might take longer to restore. I wouldn't have to give him the keys to my car as if nothing had ever happened. And it's hard to believe that even Duff maintains that all trust is restored. Take someone who's convicted of molesting a child. Now, many registration laws are counterproductive and our restrictions are over-inclusive, overbearing, often unjustified. But maybe, just maybe, a convicted child molester should not get to work in a public school as a kindergarten teacher upon release. So what I propose here is that even after punishment, it is appropriate to withhold complete trust so as not to fully restore the presumption of law-abidingness. Instead, the commission of the wrong may put the person on moral probation. Consider Alice, whose wife Betty has cheated on her, but they have stayed together. In the ordinary relationship, one might not have grounds to be suspicious just because one's partner was out late at night with a coworker. But Alice might be entitled to additional grounds for concern, or the right to react on lesser evidence than is otherwise warranted. Betty's status as a faithful partner is more vulnerable because of her prior choices. So if we're not entitled to a full restoration of law-abidingness, or the status of law-abidingness, then the way in which we re-earn that right over time might actually be quite nuanced at the moral level. All offenses may threaten the presumption of law-abidingness, but punishment restores most of the status. Still, small interventions might be permissibly justified in ways that pretrial detention is not. That is, assume that convicted felons are more likely to reoffend if they lose their job within 6 months of release from confinement. Would the state be entitled, not simply as a matter of helping the person, but as a matter of preventing harm to the rest of us, to intervene and impose conditions that minimize the likelihood of reoffending? For our purposes, the idea behind moral probation is that some offenses are sufficiently significant that they leave a continuing impact on the presumption of law-abidingness. They lie between crimes that are so significant that detention could be warranted immediately going forward, and minor offenses for which defendant's punishment results in the full restoration of status. Again, the idea is that the moral status as presumptively law-abiding is and should be weakened when one is not law-abiding, and that punishment does not fully restore that. Nevertheless, we want to give previously convicted people every opportunity to flourish. The goal is not to impact their reintegration into society. We do owe offenders support, particularly in our society as it's currently structured, and we ought not to unduly hamper their success. A walking in permanent vulnerability, a forfeiture of any assumption of law-abidingness forever, seems to deny the offender the opportunity to show that they are entitled to the restoration of the presumption. What does seem warranted, though, is a probationary period in which we help previously convicted persons reintegrate, and they do their part to show us their good faith in fully restoring their status among us. Now, one might ask whether any milk buyer might be on moral probation. In fact, Patrick Tomlin asked me that 2 days ago. So here's the answer. Is he subject to the great algorithm if it pings? This turns on how much status we think someone should lose. I think we want to give those released freedom to pursue their projects without fear that we'll simply predict. It's incredibly freedom limiting to feel like one is walking on eggshells. We see that in our interpersonal cases, where one remains distrusted and fears that anything could set someone off. Instead, what this analysis points to is that actual probation and parole might be better conceived as giving offenders a period of time to regain their full status. This allows the state to specify the don'ts of the world that aren't crimes, but also might raise our hackles, perhaps don't associate with known criminals. From there, though, we ought to give them freedom to engage in actions without the constant worry that they will simply be predicted dangerous. Hence, both the milk buyer and the criminal defendant might be walking around with a vulnerability, but it would not be one that would allow a calculation by the great algorithm without further action on their parts. It's to that possibility that we now turn. So we should ask whether the charged offense can itself trigger forfeiture. To isolate this question, we should ask whether someone charged with a dangerous felony, say or aggravated assault, may be detained pretrial as dangerous when our milk buyer may not, assuming that neither has a prior record and the great algorithm says both are equally likely to commit a serious offense in the future. So Sandy Mason suggests that this is objectionable because of its social meaning. She claims there is, quote, a due process objection that any official judgment of guilt carries a special stigma, such that it should only be made with near certainty. So to put this in other words, the state is saying, we decided you did it, but we aren't punishing you even though we're going to put you in jail for being dangerous. And in a month or two, we'll have a trial to decide whether or not you did it. Yet, if someone may lose a medical license, a driver's license, the right to own a gun, based on substantial evidence that they've engaged in a crime, then there's no reason why morally we can't act under these circumstances. It is simply that our criminal justice system's constant sending of mixed messages, of conjoining preventive aims with those of punishment, undermines our ability to clearly distinguish one practice from the other. In this instance, the forfeiture is not about punishing, but about being subjected to the grade algorithm. Arguing for any particular burden is difficult, but it does seem that that for short-term pretrial detention, that proof beyond a reasonable doubt wouldn't be necessary. Arguably, something like the Bail Reform Act of 1984's requirement of clear and convincing evidence, along with robust procedural protections, seems to allow for the requisite showing of the forfeiture of the presumption of law-abidingness. So far I've maintained that the crime charged may be sufficient to justify pretrial detention in some cases. I've also argued that prior convictions put one on moral probation. But what happens when someone on moral probation is charged with an offense? My argument here is that a different calculation is permissible. So there are 3 steps here. First, the prior criminal conviction results in a vulnerable status. Second, some additional showing of another crime occurs. And third, the lesser evils calculation speaks in favor of detention. So let me take the 3rd step first. I don't aim to give a robust defense of how the grade algorithm ought to be calibrated. The idea is that when you don't have the status of being presumed law-abiding, then it's permissible to predict what you will do. Still, the showing is not that you are liable to detention. Accordingly, we should only aim to harm you to the extent that it would be permissible to harm any innocent person to achieve the good. That's the lesser evils calculation. With the calculation in place, it is likely we will often reach the conclusion that the least restrictive measure is something short of detention. Moreover, because this detention is not grounded in liability but lesser evils, the detainee ought to be compensated for the detention. Now, we could structure the grade algorithm differently. If the algorithm were calculating the probability that one would act such that one would have a duty and then determining the harm permissibly imposed given that duty, the grade algorithm would just be enforcing the duty one had. That determination would simply set a different epistemic threshold, the likelihood that one would engage in harmful conduct, and then apply the duty that one would have to absorb to prevent the harm. Then no compensation would be owed. So perhaps the grade algorithm can run both calculations. It is great, after all. You're supposed to laugh at that. You guys are such a serious crowd. I also haven't said anything about what evidence the grade algorithm may use. As discussed earlier, there are both questions about the kind of evidence that is accurate and the kind of evidence to which we might have normative objections because of underlying distributive inequalities. Although everyone wants accurate evidence, I believe there is much force to the contention that only certain types of evidence are fairly employed. Okay, now back to the first feature. When someone is on moral probation and thus required to stay out of trouble, their normative vulnerability leads to a different standard of proof at the second step. They have already undermined that presumption, and it is only partially restored. Thus, it seems that probable cause, instead of clear and convincing evidence, is itself sufficient to show that they are unworthy of that status. Again, that doesn't mean we detain them. It only means we get to see whether the grade algorithm says we must detain them as the least restrictive measure possible. That may often not be the case. Now, one might wonder whether the prior crime should impact the way the algorithm is configured. I don't see how that could be normatively justified. Nothing about the fact that someone has committed different crimes impacts the omniscient duty approach, and the defendant ought to be treated as a citizen whose liberty is valuable. The predicted future crime is already included in the calculation. One might also wonder whether you could forfeit your objection to the kind of evidence that's used. Again, I'm not arguing for that. Our claims about what kind of evidence may be used against us are not grounded on our presumption of law-abidingness. Instead, there are distinct worries about what it means to use purely statistical evidence or to rely on factors that trace directly to distributive inequalities. We don't lose those claims as people, even if we make it permissible to make predictions about us more generally. To summarize, I've tried to make it plausible that there is a presumption of law-abidingness, but that presumption is lost by committing an offense and is not fully regained after punishment. During this period, the evidentiary showing that is otherwise required, clear and convincing evidence is weakened, such that access to the grade algorithm is permissible in more cases. Nevertheless, the grade algorithm itself would still have to mandate that detention is permissible, and if this calculation rests on lesser evils, would require compensation. In conclusion, criminal law theorizing often operates in an awkward space between ideal theory and completely grounded application. Let me close by pushing our question in both directions. First, zooming in, my claim that one can lose one's status as presumptively law-abiding and that this is a collateral consequence of conviction should inform the practice of criminal law. Specifically, just as individuals should be advised of other implications of convictions, so too a sentencing judge should tell defendants when their convictions will figure into future determinations. We may want to rethink our understanding of what we really can and should be doing with probation and parole. As we zoom out, we might ask whether there is anything special about the commission of offenses. Rather, what offenses are instances in which the defendant has engaged in a voluntary action and the forfeiture consequence is a fair result. Ostensibly, we could have a purely preventive regime that engages in these sorts of determinations. We need not have the intermingling of prevention and punishment that we currently have in our legal system. But focusing more concretely on these particular criminal acts, which laypersons and more importantly judges find intuitively compelling as justifications for detention, allows us to interrogate where the pressure points are. Our current practices may be less objectionable as predictions, but more objectionable because these predictions are predicated on prior biased enforcement. But the question of how best to remedy unjust distributive impacts is distinct from whether any given individual did commit a serious violent crime in the past, likely committed another offense, and based on legitimate criteria, currently poses a serious risk to others. And if we recognize that we are imposing a sort of moral probation, we can simultaneously ask what duties the state has to assist the defendant in reintegrating and avoiding reoffending. Prying these questions apart is crucial for on-the-ground reform efforts.